First, day 2 of the Ketanji Brown Jackson Supreme Court confirmation hearing kicked off this morning in Washington. And as expected, the proceeding got intense, with senators getting their chance to question the judge about her legal background. Republicans have keyed in on a part of Jackson's career which dates back to 2005, where she represented 4 Guantanamo Bay detainees during her time as a public defender. Senator Lindsey Graham went after the judge for defending 4 accused terrorists, not only during her time as a public defender, but later in her career, after she went into private practice. In 2008, Jackson signed a brief on behalf of the 4 men she represented, advocating to the Supreme Court that those Guantanamo Bay prisoners not be held indefinitely. She says she was just representing a client.
You sign on to this brief making this argument, but you say it's not your position. I mean, why would you do that if it's not your position? Why would you take a client that has a position like that? Now, this is voluntary. Nobody's making you do this.
Oh, Senator, I would refer you to the same sorts of statements that Chief Justice Roberts made when he came before the committee, which is that lawyers represent clients.
I get that. I'm not holding the client's views against you. The people you represent at Gitmo, they deserve representation. But this is a amicus brief where you and other people try to persuade the court to change policy. Did you support then the idea that indefinite detention of an enemy combatant is unlawful?
Respectfully, Senator, when you are an attorney and you have clients who come to you, whether they pay or not, you represent their positions before the court.
Now, it's true that a client's position does not automatically become her position. But the far left recently opened this can of worms when it comes to federal judicial nominees. And that's my issue on this. The hypocrisy of some on the left saying lawyers should be held accountable for their clients, except when they shouldn't be. 2 weeks ago, more than 20 progressive activist groups signed a letter objecting to President Biden's nomination of Jennifer Rearden to the federal bench. Rearden, who works at the prominent law firm Gibson, Dunn & Crutcher, had initially been appointed by President Trump and then had her nomination renewed by President Biden. She's donated to candidates of both parties, but has donated more to Democrats. But the activist groups objected to her nomination in large part because she and her firm represented clients who, quote, drove the climate emergency and poisoned the environment. Specifically, the group cited a case in which she and her firm represented Chevron in a lawsuit against a former environmental lawyer who was sentenced to 6 months in prison last year for contempt of court. The activist wrote, quote, Gibson Dunn effectively blocked enforcement of the more than $9 billion Ecuadorian judgment against Gibson Dunn client Chevron for the dumping of over 16 billion gallons of toxic oil waste into the Amazon by preemptively suing the Ecuadorians and their lead lawyer, Stephen Donziger. Gibson Dunn prevented the Ecuadorians from bringing their judgment to the United States to be evaluated on its merits. Now, this case was very controversial. The records show Rearden was involved for a handful of hours. She didn't have a significant role in the case, but these groups believe that limited involvement here is disqualifying. So you might presume those same groups would have concerns about Judge Ketanji Brown Jackson because, after all, she represented terrorists and criminals. I mean, if you're going to hold lawyers responsible for their clients, then she would presumably be disqualified as well. My position is simple. It is a lawyer's job to represent a client, and a lawyer seeking to become a judge cannot be held responsible for what every one of their clients says and does. But there has to be some consistency, no matter who the lawyer represents. Lawyers sometimes represent bad people. So I don't understand how these groups can oppose Rearden because she represented a big, bad corporation, but now support Judge Jackson, even though she's represented dangerous criminals and terrorists. Joining me to tell me what I am missing here is Colin Reese. He is the U.S. Program Manager for Oil Change International, one of the groups which signed on to the letter opposing Judge Rearden, but they support Judge Jackson. Colin, thanks so much for coming on the show. Appreciate it. What am I getting wrong here?
Thanks, Dan. I mean, I think the biggest difference here is the difference between a job as a public defender, criminal defense, which is what we saw with Ketanji Brown Jackson, and a job as a corporate lawyer, spending nearly 20 years at one of the nation's largest and most powerful law firms defending the interests of corporations rather than the interests of people.
But I thought the focus was on the client, right? Because it seemed that the focus in your letter was the representation of Chevron, right? And what Chevron had done in this context, et cetera, that was the problem. And yet I don't see how you can say on the one hand that representation of a big bad company like Chevron should be disqualifying, but representation of terrorists and other bad guys shouldn't be.
So that's the difference between public defense and corporate law here. Public defenders do not get to choose their clients. The Sixth Amendment guarantees the right to a lawyer. And so Ketanji Brown Jackson spent a couple years as a federal public defender. She did not choose her clients. She represented the interests of those clients and has repeatedly said that she did not condone the actions of those clients or those which had not been proven guilty yet in many cases. Judge Rearden, or Jennifer Rearden, on the other hand, chose to spend 20 years at Gibson Dunn representing corporations. She can choose her cases. The model rules of professional client allow any lawyer to withdraw where they insist, where they would be having to represent something that they are fundamentally opposed to. They have a fundamental disagreement. We think lawyers should have a fundamental disagreement with defending somebody like Chevron in a case like this. I think it's a very different situation than a public defense situation as you have with Ketanji Brown Jackson, where she is not choosing her clients.
But I'm not so sure that's true. I mean, this is where I think Lindsey Graham has a fair point, right? Which is when Judge Jackson signs on to an amicus brief in support of the Gitmo detainees, and I believe she may have been even doing it pro bono, while she was in private practice, no one sort of assigned her that case, et cetera. No one demanded that she do that. She chose to do that, and that would seem to be, I think, a stronger argument that it reflects her personal position than, again, Judge Jennifer Rearden spending whatever it was, 18 hours working at a very prestigious firm on a case that you guys are particularly opposed to, no?
Yeah, I mean, I think this is about much more than just the Chevron case. I think that's true in a vacuum, but when you have 20 years of working for corporate interests, when you have Jennifer Rearden spending her pro bono efforts trying to overturn Department of Labor rulings against charter school associations, helping New York landlords, this is what she is choosing to spend her pro bono time doing. So I really don't think these things are comparable. I think you have one person who has served at various levels of the law, spent time in public defense. By the way, she would be the first Supreme Court justice with significant time spent as a public defender since Thurgood Marshall. I think President Biden has been very clear about his desire to diversify the federal judgeship, make it so that the federal judgeship better represents America. I think what we don't need is another corporate lawyer who spent her entire career defending corporations.
Well, but that's really the point, right? Is that you guys don't like corporate lawyers, but you do like criminal defense lawyers. And it would seem to me that that would be the more intellectually honest way to say, look, our position is we don't like corporate lawyers. We don't like what they do. We really like criminal defense lawyers. That seems to me to be a more honest way to view your position, no?
I don't think that's entirely accurate. I mean, I think there is a lot of truth there, but that's not the sum total of this. If there's something that comes out during Ketanji Brown Jackson's hearings that we don't approve of, we might not support eventually. Everything that we've seen so far, the balance of the evidence is that she would be an excellent Supreme Court justice. If we learn, for instance, that she had been a part of a team that bribed a witness with $2 million in cash and benefits, we would probably condemn that nomination in a heartbeat. And that's exactly what Jennifer Rearden did.
Yeah, but again, holding against one person their clients and another person not. But I appreciate the argument, and I appreciate the conversation and your time. Colin Reese, thank you.
Thank you, Dan.
Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.